Dear students, I welcome you to yet another lecture on corporate law. The theme of today's lecture is shareholders and members. In today's lecture, we shall discuss who can be the shareholder of a company. We shall also discuss the modes of becoming a shareholder of a company. Forfeiture of shares, lien on shares and surrender of shares shall also be discussed on today's lecture. A company's share represents the units into which its capital is divided. To put it in another way, it is dividing the company's whole paid-up capital into smaller units in order to raise funds. The buyer of this unit becomes the shareholder, and the percentage or part of money provided by a person to make up the capital is known as shares. Anyone who has a share in a company is referred to as a shareholder in common parlance. A shareholder can be a person, an institution, or another company. If the company does well, the shareholders benefit through appreciation in the value of their shares. However, if the company incurs losses, the shareholders can also be at a loss due to fall in stock prices. Shareholders of a company are also known as members of the company under the Companies Act 2013. The terms members and shareholders are used interchangeably. In general, every shareholder is a member and every member is a shareholder. However, there may be exceptions to this statement. For example, a person may be a holder of shares by transfer but will not become its member until the transfer is registered in the books of the company in his favor and his name is entered in the register of members. Similarly, a member who has transferred his shares, though he does not hold any shares yet, he continues to be the member of the company until the transfer is registered and his name is removed from the register of members maintained by the company. Two important elements which must be present before a person can become a member of a company are: number one, agreement to become a member; number two, entry of the name of the person so agreeing in the register of members of the company. Dear students, we shall now discuss the modes of acquiring membership of a company. Section 2, Clause 55 of the Companies Act 2013 defines a member as: number one, the subscribers to the memorandum of a company who shall be deemed to have agreed to become members of the company and on its registration shall be entered as members in its register of members. Number two, every other person who agrees in writing to become a member of a company and whose name is entered in its register of members shall be the member of a company. Number three, every person holding shares of a company and whose name is entered as a beneficial owner in the records of a depository shall be deemed to be a member of the concerned company. We shall discuss each of these in detail. The first one is subscribers to the memorandum. In the case of a subscriber, no application or allotment is necessary to become a member. By subscribing to the memorandum, he is deemed to have agreed to become a member and he automatically becomes a member on the incorporation of the company and is liable for the shares he has subscribed. In Re Metal Constituents Company, it was held that once a person has subscribed to the memorandum, he cannot rescind the contract for the purchase of shares, even if there is fraud on the part of the promoters. According to Section 10, Clause 2 of the Companies Act 2013, all monies payable by any member to the company under the memorandum or articles shall be debt due from him to the company. A subscriber to the memorandum must pay for his shares in cash even if the promoters have promised him the shares for services rendered in connection with the promotion of the company. Again, he must take the shares directly from the company and not through transfer from other members. Number two, by allotment. A person becomes a member when he applies for shares and they are allotted to him. A notice of allotment is issued to him and his name is entered in the register of members. To constitute a valid allotment, it is essential that there is an agreement in writing and there is a transfer of shares. A person can become a member by acquiring shares from an existing member and by having the transfer of shares registered in the books of the company. That is, by getting his name entered in the register of members of the company. The third mode is by transmission of shares. A person may become a member of a company by operation of law. That is, if he succeeds to the estate of a deceased member. Membership by this method is a legal consequence. On the death of a member, the person who is entitled under the law to succeed to his estate gets the right to have the shares transmitted and registered in his name in the company's register of members. No instrument of transfer is necessary in this case. Number 4 is by acquiescence or estoppels. A person is deemed to be a member of a company if he allows his name without sufficient cause to be in the register of members of the company, or otherwise holds himself out or allows himself to be held out as a member. In such a case, he is stopped from denying his membership. Another mode of becoming a shareholder in the company is by holding shares as a beneficial owner in the records of a depository. Every person holding shares of the company and whose name is entered as a beneficial owner in the records of a depository shall be deemed to be a member of the concerned company. Dear students, now we discuss who can be the shareholders of a company. The first category is minors. A minor lacks the legal capacity to enter into a contract. Hence, his or her contract is void. A guardian can enter into a share purchase agreement on behalf of a minor and the agreement will be lawful. In Golconda Industries versus Registrar of Companies, the court held that a registrar cannot refuse to accept a return of allotment in which minor is shown as an allottee. The court admitted that the law relating to minors' membership of a company is still uncertain. The next category is Hindu undivided family. For all intents and purposes, a Hindu undivided family is treated as an individual rather than a legal entity. A company's shares can be registered in the Karta's name. As a result, a Hindu undivided family can become a shareholder in the company. In the case of Vickers Systems International Limited versus Mahesh P. Keshwani, it was held that a company's shares can be registered in the Karta's name. The next category is partnership firm. A partnership firm is not a separate person or a legal entity from the partners who make up the partnership, but rather a collective designation for the individuals who make up the partnership. As a result, a partnership firm is not a legal entity. A partnership firm can buy shares in the name of the individual partners. The next category is company. A company may join another company as a member if its memorandum of association or articles of association permit it, or if it acquires the shares of another company through a compromise or arrangement. A company, on the other hand, cannot purchase its own shares except in the limited manner provided under Section 67 and 68 of the Companies Act. The next category is non-resident Indians. Foreign companies, foreign nationals and non-resident Indians are all permitted to become shareholders in Indian companies subject to foreign direct investment legislation and the FEMA standards. The next category is limited liability partnership. A limited liability partnership is a legal entity that can own assets and properties in its own name. Limited liability partnership can become a shareholder of a company by signing the company's memorandum of association or purchasing shares subsequently. The next category is the central or the state government. The President of India or the Governor of a state can become a shareholder on behalf of a company of any of the state governments or the central governments. According to the Act, either the President of India or the Governor of a state may designate anyone to attend any meeting of the company. The person so nominated might be regarded as a shareholder of the company with the same rights and powers that the President of India or the Governor of the state would have if they were the shareholders. Dear students, we shall now discuss forfeiture of shares. When a member or a shareholder fails to pay the call on shares or installments of the issue price of his shares within a certain period of time after they fall due, the company may forfeit the shares of such a member. This is called forfeiture of shares. Thus, when the shareholder fails to pay the full amount of shares which he has agreed to pay in installments, the company can cancel his shares. Dear students, we shall now discuss the legal framework with respect to forfeiture of shares. When the shares are issued by the company, generally the shareholders are not asked to pay the whole amount of shares at once. It happens in installments. The company makes these call on shares when it requires further capital. The company may call up the unpaid money from the shareholders when it is needed from time to time. The board of directors are required to pass a resolution for making a call on shares. The articles of the company should contain the provisions regarding this call on shares, and if nothing is mentioned, then the regulations of Table F of Schedule 1 of the Companies Act 2013 will apply. Procedure for forfeiture of shares. Forfeiture of shares is penal in nature since it involves in depriving a person of his property as a penalty of some act or omission. Accordingly, shares of members can be forfeited only if the articles of the company confer such powers on the directors. The forfeiture of a share should happen only on the grounds specified in the articles of the company. Usually, forfeiture is made on the ground of non-payment of the call on shares by the members. But it is important to remember that it can also be made for any other grounds which are specified in the articles of the company. Companies normally have their own rules and regulations regarding the forfeiture of shares, and in case if those provisions are not present, then regulations 28 to 34 of Table F of Schedule 1 of the Companies Act 2013 will apply. The first principle is that it must be in accordance with the Articles of Association. In order to be valid, forfeiture of shares must be in accordance with the provisions contained in the Articles of Association of the company. The power of forfeiture of shares must be exercised bona fide and in the interests of the company. Thus, in Dilbajan Singh versus New Samudri Transport Company Private Limited, where the buses of the transport company were divided into two groups of shareholders, each group operating them separately and one group making losses, it was held that the forfeiture of the shares was not justified. The second principle is that there must be proper notice. A proper notice under the authority of the board of directors must be served on the defaulting shareholder. The notice should specify the amount and the date by which the shareholder has to pay the amount. However, the time given for payment should not be less than 14 days from the date of notice served. This is provided under Regulation 29 of Table F. The notice should also mention that in the event of non-payment, the shares will be liable to be forfeited. The purpose of sending the notice is to give the defaulting shareholder an opportunity to pay the call money, interest, and any other expenses, and hence the notice should disclose all the relevant information to the shareholder. A proper notice is a condition precedent to the forfeiture of shares, and even the slightest defect in the notice will invalidate the forfeiture. This was held in the cases of Public Passenger Services Limited versus M.A. Khadar. In Promila Bansali versus Wearwell Cycle Company, a notice was sent for forfeiture by registered post. It was returned unserved. The court held the forfeiture to be invalid. A notice sent to the holder of a partly paid share after his death is not a proper notice. Notice in this kind of a situation is to be sent to the legal heir. The next principle is resolution for forfeiture. If the defaulting shareholder does not pay the amount within the specified period mentioned in the notice properly served to him, the directors of the company may pass a resolution forfeiting the shares under Regulation 30 of Table F. In the absence of such resolution, the forfeiture shall be invalid, unless the notice of forfeiture incorporates the resolution of forfeiture as well. For example, the notice may state that in the event of default, the shares shall be deemed to have been forfeited. Dear students, we shall now discuss the effects of forfeiture. The first effect is cessation of membership. A person whose shares have been forfeited ceases to be a member in respect of the forfeited shares. This is provided under Regulation 32 of Table F of Schedule 1 of the Companies Act 2013. Regulation 32 provides that a person whose shares have been forfeited shall cease to be a member in respect of the forfeited shares, but shall, notwithstanding the forfeiture, remain liable to pay to the company all monies which at the date of forfeiture were presently payable by him to the company in respect of the shares. The liability of such person shall cease if and when the company shall have received payment in full of all such monies in respect of the shares. Liability as a past member. The former shareholder whose shares have been forfeited shall remain liable as a past member to pay calls if the winding up of the company takes place within 1 year of the forfeiture. Forfeited shares become the company's property. The forfeited shares become the property of the company upon forfeiture. Regulation 31 says that a forfeited share may be sold or otherwise disposed of on such terms and in such manner as the board thinks fit. Clause 2 of the same regulation provides that at any point of time before a sale or disposal of forfeited shares, the board may cancel the forfeiture of the shares in terms as they think fit. Dear students, we shall now discuss surrender of shares. Surrender means voluntary return of shares by a member to the company. Shares which are liable to be forfeited on account of default in the payment of calls may be surrendered by the holder if he so desires. The Companies Act does not provide for surrender of shares. However, such voluntary surrender of shares can be accepted by the company provided it is authorized by the articles of the company. The formalities with regard to the forfeiture are then unnecessary and the shares are deemed to have been forfeited and cancelled without the detailed procedure otherwise required for the purpose. Dear students, it is important to remember that surrender and forfeiture of shares have practically the same effect. The only difference is that forfeiture is done at the instance of the company, whereas surrender is done with the assent of the shareholder. Dear students, we shall now discuss the right of lien. A lien is the right to retain possession of a thing until a claim is satisfied. In the case of a company, lien on a share means that the member would be debarred from transferring his shares unless he pays his debt to the company. The articles generally provide that the company shall have a first lien on the shares of each member for his debts and liabilities to the company. The right of lien is not inherent but must be clearly provided for in the articles. The articles may give the right of lien over shares either for unpaid calls or for any other debt due by the member of the company. The company may have a lien on fully paid up shares. The lien also extends to the dividends payable on the shares. The death of a shareholder does not destroy the lien. Where the liability of the shareholder towards the company is disputed by him, it does not deprive the company of its right of lien on the shares. Where the shareholder has mortgaged his shares before he has incurred any liability to the company and the company has notice of it a company will not be able to exercise its right of lien. Similarly, a company will lose its lien if it registers a transfer of shares subject to the lien. Dear students, this is all with regard to today's lecture on shareholders and members. In today's lecture, we try to understand the definition of a member of a company. We also try to understand the modes of becoming a shareholder of a company and who can be the shareholder of a company. We also discussed forfeiture and surrender of shares. Hope you have understood the lecture and have been able to enjoy it. Thank you and stay blessed.